Let me say something very controversial today. Most law students are actually never taught how to draft contracts properly. They are taught sections, they are taught definitions, they are taught case laws, but nobody teaches them how badly one drafted clause can destroy a pure business deal, ruin a client relationship, or maybe trigger litigation worth crores or completely damage a lawyer's reputation. And here is the most scary part. Some lawyers, even with years of experience, are still making the same basic drafting mistakes. They download templates from Google, copy clauses they don't understand, use fancy language to sound intelligent, and send the same agreements to the clients without even understanding the commercial transaction. And with AI and ChatGPT, this is a common problem that I have been facing with a lot of clients, especially in the startup era, wherein founders they just download the agreements, whatever is available, copy paste clauses from any random agreements, and then send it to you for review, which in turn turns out to be double work because it is not, first of all, legally drafted according to your requirement. And just like every individual, every uh, agreement is different. So today's session is technically not about how you draft a contract theoretically, but in today's class, we are going to discuss about the biggest mistakes that lawyers and law students make while drafting contracts. Why understanding the law alone or understanding the technicalities of law alone is not important. Why client counseling is the most important step that every lawyer needs to take before drafting a contract. Why the first draft should never be the final draft. Most lawyers make this mistake. They make the first draft the final draft. Understanding why exactly some lawyers charge lakhs of rupees for a contract, whereas somebody just charges merely 500 rupees. The answer is the quality of contract. So, how do professional lawyers actually draft contracts is what you need to understand. How can you avoid the liability as a drafting lawyer? Now, most of the times it may happen that your client will come and say कि यार ये तो मेरे client ने मेरे lawyer ने draft कर दिया है. I don't understand any of these clauses. The lawyer forced me to draft. Happens. How to become the kind of a lawyer that client trusts you with high value deals. Now, if you see that most of the times, whenever a client is entering into a very high value deal, that is wherein crores of, the transaction is worth crores of rupees, they may approach a different lawyer. They may approach a prominent lawyer and not give a chance to a fresher. And I'm sure as law students, this is a challenge that even you yourself have been facing. The reason for this is because your contract drafting is not about uh, typing a few words in a Word document. It is mainly about what is the strategy that you're going to use. It is about how are you going to manage the risk. Maybe the deal in which your client entered in is not, something that is going in his favor. But right contract drafting can help you protect your client from future unseen circumstances. Contract drafting is also psychology, the most underrated skill set of a lawyer. Understand what your client wants, understand what your opposite side wants, because many a times people may not be able to express their requirements. They may not be able to tell you that, hey, see, I don't want any of the difficulties in future with respect to A, B, C, D. Now, up to D option, your client will tell you, but what about E, F, G? That is something that you need to foresee, understanding the situation. It is also a skill set of negotiation. Negotiation, if I were to describe, doesn't always mean whoever is louder in the room wins or whoever can say the most convincing lies wins. No. Negotiation is about taking what is the best for your client at the right time. Now, you may while negotiating, it may happen that your client and the other side, you both are sitting together and trying to negotiate, try to bring a conclusion. There are chances that circumstances may not change even after 6 months. But your client wants to take the risk of 6 months. Let's wait, let's renegotiate everything. But when you're waiting for 6 months, there is a lot of loss that is simultaneously happening. One is, of course, loss of time. Two, do the circumstances really change in the next 6 months? These are a few things that you need to analyze first and then convince your client. A step that I have seen a lot of lawyers fail because they are very short-sighted. You have to be far-sighted and understand what is the impact financially, what is the impact mentally. The biggest challenge I have seen is created by lawyers themselves, who feel that, the more complicated contracts we draft, the more money we can earn. What they don't understand is it's very difficult to draft a simple contract which is convincing and which protects all your rights today as well as in future. Now, as I said, sometimes contract drafting is all about avoiding crisis. That is your legal suits, your litigations, your criminal complaints, which may all arise in future. By the end of this video, you will never look at the legal contracts in the same way. Now, before discussing the mistakes, let us understand one important thing. Why exactly is contract drafting one of the highest paying legal skills globally? Because businesses do not pay lawyers only for litigation. Good businesses also pay lawyers to prevent litigation. A well-drafted agreement always prevents disputes, it clarifies the obligation, it reduces the confusion, it also protects, the physical property as well as intellectual property. It defines what is the liability of both the parties. It also secures the payments on behalf of both the parties, that is the person who is giving and the person who is receiving. And it also helps you build trust between both the parties. So these were the skill sets that I spoke about in a good contract. Now, what is the damage that is caused by, a badly drafted contract? So your badly drafted contract is, like that friend we all have who listens half the story, inserts his own mirch masala, and then tells the world. So basically, a badly drafted contract, it always creates ambiguity, due to which there is always a breach of contract, or maybe the proper enforcement of contract doesn't happen. It often leads to lawsuits. It creates your financial losses. And sometimes in future, it may also create unnecessary commercial, damage to the commercial relationship between the parties. Now, majority of the clients, I'm sure even you never read 40 to 50 pages of contract. But whenever there is a dispute, when we go for litigation, every single word, every single full stop, every single comma, every single date, everything plays a huge role. So that is why when you talk about contract drafting, it's not a copy paste job. It's not a clerical job. It's a proper legal architecture, even if it was only contract. Now let's start with the biggest mistake. The mistake number one of not understanding the law. Now, if I am drafting a contract, let's say about property, okay, sale of property, it is important I understand what are the rules of that particular state. Now, the sale of property, the rules and regulations that apply in Maharashtra are not same as those it would be in Bihar. The rules, the laws that apply for sale of an apartment is not similar to the rules or the laws that apply to the sale of an agricultural land. The stamp duty for both these properties will be important. So if I'm talking about a contract, I need to understand which are the laws applicable. What is the purpose? So therefore, this is the first and the most dangerous mistakes. Because many lawyers just draft contracts without even understanding the governing law behind the transaction. So let me explain one simple thing. Okay. You cannot draft an employment agreement without the basic knowledge of labor law. Why? Because the laws that will be applicable for a senior management, the clauses that you would include in the employment agreement of the senior management will not be the same as those you would apply for, let's say, a factory worker. You need to include sections which are governing the labor law for a franchise agreement without understanding competition law or trademark law, again, is a disaster. If you don't understand how competition law works, or how, when you open a franchise, you give out a lot of your intellectual property to your franchisee to use for advertising, for, using it for the interior of the store, for their social media promotions, etc. If you don't understand how a trademark law protects the trademark, your logo, your word mark, etc., then you cannot draft a franchise agreement. You cannot draft a software licensing agreement without understanding intellectual property law. Like, for example, I've had a lot of people who came up to me and said that, let's register a patent for software, but you cannot register for a patent for a software until and unless it is accompanied by a physical device. That is the minimum requirement. So if there is no physical device, you cannot register for a patent. A lot of people don't understand that even when we talk about software, okay, the code is a literary work under copyright, but the name of the software is the trademark. You have, the goodwill of the software, that is again the trademark. So understanding these basic nuances or basic terms, or, what will amount to infringement, because you are drafting a contract only to avoid the infringement in future. So if you don't understand the basic law, you don't understand that, in a real estate agreement, if you don't have the property law knowledge, as I said, if you don't know when are you going to apply for, let's say, do you need to transfer a land which belongs to a trust? What is the procedure? You're going to go to the charity commissioner, get an order, and then transfer. So if you don't know such basic procedures on how to do due diligence for a title, that is one major mistake I have seen lawyers do. Again, another example is about a data privacy clause. Now, without understanding data protection laws, you cannot implement a data privacy law. We often talk about, how some companies have very bad policies. So it's never the intention of the company to have very restrictive policies, okay, which will, restrain the employees from working or not give sufficient, freedom to work. It's always a badly drafted HR policy, or it's usually a badly drafted employment contract, which does not explain the obligations of both the parties. Something that's very simple, something that's very much of a common sense, yet many people create this disaster. They copy the templates from the internet. You can use it as a reference, but there is something that you need to understand carefully. That is, your contract is not just a language, okay? It is an enforceability. So if a clause, a contract clause is, now understand something very carefully. A contract is not just a language. It's something that has to be enforced before the law. That is the difference between an agreement and a contract. So even if one of the clauses are illegal, or, it is not something that can be implemented, which is going against ultra virus, maybe it is vague, maybe it is ambiguous, maybe it is going against the public policy, it will become unenforceable. Okay. For example, you have your non-compete clauses. Now, majority of us know that non-compete clauses in India are something that's heavily restricted under Section 27 of the Indian Contract Act. Yet, a lot of people end up adding Section 27. Now, the reason for the same is because in India, we don't have any clarity on dual employment. That is, a person working at two places at once. So having non-compete clause or exclusive clause becomes very difficult. Let's talk about penalty clauses. Now, penalty clauses may not always be enforceable under Section 74. Certain indemnity clauses may also be, in conflicting nature with the statutory provisions. Sometimes even arbitration clauses are drafted so badly, it is drafted just for the sake that, even the courts refuse to enforce them. For example, if you are drafting an arbitration clause, okay, and one side you have a corporate giant, on the other side you have a simple employee who's going to, who earns probably 15 to 20,000 per month. You can't put a clause that, you will have institutional arbitration. Now, as a lawyer, you need to understand that institutional arbitration is something that's very expensive and can be, managed by only big giant corporates and not a person who merely earns 15,000, because arbitration is also very expensive. Understand the nature, understand the procedure, and understand the law, understand your client's requirements before you even start drafting. Okay, so I'll just give you a few pointers. What are the things that you need to identify? You need to identify which law applies, which jurisdiction. Okay, now both the parties reside in Bombay, but maybe your template agreement said that arbitration has to be carried out in Delhi. That doesn't mean the arbitration clause in your agreement should also say it should be carried out in Delhi. Which statutory restrictions or resistance should you apply? Section 27 may not be applicable when you are hiring, let's say, an office boy or a clerk. But if you're working in a very high value agreement, or you're working in a very sensitive agreement, or you're working, with a senior management who holds a lot of confidential information, yes, then you can have statutory restrictions. Which clauses are mandatory? Why is it important to use certain clauses? Which clauses become void? For example, you can have premarital agreements in India, but which prenuptial agreement, not premarital, sorry, which prenuptial clauses are, which is enforceable and which is not enforceable? How are you going to navigate through those challenges? So a person who is a very good drafter, he studies the law first. And a bad person, very bad lawyer will just start copy pasting everything that he finds from Google. Moving further, one of the biggest drafting disasters that I have seen happen is when lawyers understand the law but don't understand the nature of the business. Now, clients don't come to you, just to get that technical term or because they have a lot of money. They also come to you for commercial protection. For example, if your client says, okay, that they run a digital marketing agency. Now, if you start drafting a service agreement, let's say, without understanding the basic concepts, what are the basic concepts I need to understand when I'm drafting a service agreement? Now, if I'm doing it for a digital marketing agency, I need to understand their revenue model. For example, if the digital market agency is producing the content, then they become the owner of the content. It is not the brand, or it is not, the manufacturer who has hired them. The work for model doesn't work. The way different industries work in India is very different from the textbook law that you learn. You need to understand the payment cycle. For example, in the media and the marketing industry, payment is made within 30 days of the deliverable of the final product. Let's talk about deliverables. How is the deliverables made? Now, are you going to give them only the final copy? Are you going to give them the rough cut? If you're going to give them the rough cut, then who is going to provide you with the hard disk? Okay, your rough cut is all those rough images or all the BTS that you use. Now, if you're providing them with these rough cuts, does the brand or the client have the authority to reuse it for their further projects. Again, this is something that you need to understand and mention in this agreement. Who owns the intellectual property? Now, one of the reasons why there is so much of vagueness in this advertising industry is because they don't enter into contracts. They just try to sort everything out in the email itself, and email never talks about IPR until and unless there is a dispute. So when I say that it's the marketing agency who owns the content, it's a very informal way. There is no formal law, but that has been the practice. Now, I've been working in the media industry. That's why I know. I know people who are producers. I know people who are from the agency. I know people who are creators. So I know everybody's perspective. Talk to people from every different profession. Again, one mistake I've seen a lot of lawyers and law students do is when you talk about networking, they feel that networking may you just need to know people who are placed in tier one law firm. That is not how you do networking. When you talk about networking, it's about talking to people in different fields, people who belong in different professions. How do I know that this is how this industry works? Because I did my graduation in mass media, I understand a few of the technicalities and I have friends. How do I know that this is how an agency works? I work as a content creator. It's not possible for you to work in different fields, but talk to people, socialize. When you go out, ask people what do they do, how is their work going on. That is how you will understand. Sometimes it is not possible to learn everything through lectures, because your biggest lecture or your biggest lesson is life. Talk to people, understand how things work. How many client revisions are you going to do? Whether it is 2, whether it is 3. Otherwise, your client will keep on making you do revision. What is confidential information? Is there any confidential information? Is there any freelancer that you are going to hire, or is the brand that is going to hire? What are the international laws? Now, are they going to register for a copyright? Are they going to register for the trademark? Do you need to take care of, is the trademark registered? Is the trademark pending? Now, maybe their trademark is, your client, you're making an ad film, your client's trademark is not registered. And yet they want, a video to have the logo of the cold drink or whatever. And what happens if the trademark gets rejected? God forbid. It's a huge loss for everyone. Think about problems which do not even exist. So while drafting an agreement, you have to technically turn into a pessimist and imagine all sorts of problems that will come on your client. That is one of the best ways to cover all the corners. That is the only way in which your agreement will fall in practice. Because a good agreement must always reflect the business reality. So before drafting any contract, ask what exactly is the transaction? How much does the client make, or how much is the client going to earn out of this? Now, if I have a client who barely makes his ends meet, I cannot charge 1 lakh for that contract. I have to charge according to his requirement. Now, in this contract, if what is the benefit of the client? If I keep on adding a general payment, structure, that is not going to work. He has to get the payment before any deliverable is given by him, or immediately within 48 hours of his deliverables. What is the biggest concern of the client? The agreements that I have seen failing is because the biggest fear is never addressed in the agreement. The lawyers most of the time feel that they know it all. They never take inputs from the client. And that is how a lot of lawyers have also lost clients. And because some of them are very good listeners, they have also gained a lot of clients. Then you also need to understand what are the risks that is commercially acceptable. Now, many law students think that drafting means just about inserting clauses, but no, drafting just means understanding the human and commercial behavior. Understand human behavior works on emotion. Commercial behavior works on how the entire field or how the entire network works. Let's talk about importance of client counseling before drafting. Now, I've been a judge for several client counseling, you know, competitions. And one thing I need to tell you is whatever do you in those you learn or you practice in those competitions, you need to undo it as soon as you come in a real life. Okay. Most of the times it is very difficult to unlearn what you learned in the law school. And that is why a lot of students find it very difficult in the first 6 months. Now, client counseling is definitely a skill that nobody teaches properly. Many lawyers think that, drafting starts as soon as you open a Word document and you just copy paste a draft. No, your drafting always starts with a conversation. Understand what exactly is the nature of agreement that would be required. A lawyer should always know how to ask the right questions because your client can express his fears. But as a lawyer, you have to be a fortune teller and understand what are the problems that your client may face in the future. Your client themselves may be confused. It happens because they are human beings and they are not technical people. So sometimes, it may happen that a founder may say that I want to go for a partnership. I need a partnership agreement. But what happens in reality is you don't get funding for partnership. You get fundings only when a proper private limited company is formed. So maybe after counseling, you realize that one person is investing 99% and other person is just, barely investing 1 or 2%, maybe in his skill sets or money wise. It is not fair to have a partnership agreement in this case. So imagine drafting these agreements without clarifying points like, who owns the brand in case of a partnership? How exactly is profit sharing done? Why are the exit rights, undefined? Because a lot of startups are not defined by how they raise funds. A lot of startups are defined by how the angel investors or founders exit, with how much of, proportion. Now imagine drafting without clarifying these issues. It's a basic disaster. So a good lawyer does not merely draft. A good lawyer always extracts information strategically. And before drafting, always ask, what exactly is your objective? What are you trying to protect? What are your worst case fears? What happened in your previous disputes? What outcome do you want if the relationship breaks down? Now, your client counseling prevents vague drafting. So remember that most drafting mistakes are not even drafting mistakes. It's just mere communication failure. The third major mistake that I have seen a lot of lawyers, even senior lawyers with 10 to 15 years experience, they make, which is very common. It's common between junior lawyers, it's common between interns, it's common between freelancers, it's common between startups, it's common between small firms. People use downloaded agreement from Google and assume the contract is valid. But it's not always. The templates are dangerous because different jurisdictions have different law. If you see online, most of the agreements with respect to software protection or, copyright are based on the US laws. And people happily copy paste them. Your copyright, software licensing, etc., without understanding that the laws that are applicable in US are entirely different from what is applicable in India. You need to understand that, the commercial arrangements for different agreements are different. You may share, the rights. You have digital rights, which you may share. You may share revenue, you may share royalty, or it may be a one-time payment. The tax implication in different countries, the tax implication for different individuals is different. Your regulatory compliances are different. Your industry standards, as I said, the property industry works differently, the film industry works differently, your software industry works differently. So therefore, your compliances and requirements are also different. Sometimes I've seen people leave irrelevant clauses inside, those agreements. That is because they just copy paste whatever they get. I've seen people leave, like US law clauses inside Indian agreements. Again, as I said, most of the templates which are available online are US based. Even those paid templates that you may buy, or people say that they have collated. No, they are not Indian templates, they are US based templates, which are usually provided to these LPOs, and then they just put it online. So, as I said, you can't have institutional arbitration, or you can't have arbitration in London or Singapore when you are drafting an employment agreement for a company which is based out of Mumbai. That becomes very difficult, and nobody reads these boilerplate clauses. You mention wrong party names, you mention incorrect dates, there are contradictory terms with respect to payments, notices. You also have a lot of clauses which are referring to the laws which no longer exist. So never treat the templates, as your final agreements or finished products. Coming now to the fourth mistake that I've seen a lot of lawyers do is, many lawyers think that, when you use a lot of complicated or fancy language, then you are very smart. You have drafted a very good agreement. No, that's not the reality. Actually, it becomes very dangerous because your client doesn't understand. Your contract should always be clear. It should always be precise. It should be unambiguous. It has to be something that is commercially applicable and both the parties understand. If your client is not able to understand the basic obligations itself, your legal drafting has failed. So always avoid unnecessary long sentences. I have seen lawyers and law students draft sentences like paragraphs. Every sentence should be not more than 8 to 10 words. That's it. Don't write sentences like paragraphs. Avoid that. You use fancy British style legal language. Not necessary if the front person is not going to understand. The person should be able to see a document, read, and then understand. He should not refer to a dictionary. He should not refer to another lawyer. Don't repeatedly use words just because it's fancy or you learn something. Please use the words only only of which you understand the meaning. Don't use ambiguous expressions, especially in divorce petitions. They say they start with the story in one place and then they end the story with that. It's a disaster. For example, instead of saying the party of the first part shall herein therefore undertake, you can simply say, no, the vendor shall deliver the goods within 15 days. Because the simpler document you draft, and trust me, drafting a simple document is more difficult than drafting a fancy, complicated document. So just simply draft, because it not only reduces litigation, even God forbid your document goes in litigation, judges also prefer clarity because nobody wants a complicated life. Everyone wants a clear cut life. So let's move on to the fifth mistake, that is ignoring definition and interpretation clauses. Now, a lot of words have different meaning, but what is the meaning of that word with respect to the relationship that I have with the front person? That is what matters a lot. So one poorly defined word, it can change the meaning of the entire contract. For example, what does your confidential information, your cause, your gross negligence, your business day, your affiliate, your force majeure? These are a few definitions which are boilerplate and used in every contract. What do they exactly mean as per your transaction? Now, when I say business day, maybe I work only 5 days a week. So it is going to mean from Monday to Friday. So it means my goods need to arrive on 15th of every month. If it's a Saturday or a Sunday, then it will be the following business day, which is it is going to reach on Monday. So it will be the 17th of day of the month. Now, when I talk about gross negligence, what exactly is gross negligence? Now, let's talk about the shipping industry. Okay, you have these huge consignments which come. Let's talk about the current scenario. There is a war that's going on. The Strait of Hormuz was blocked. Now, shipping industry also, insurance is a huge money in this. So you have taken all the precautions. Okay, you have sealed the goods, you have served them in a room temperature. Let's say those were perishable goods. Now, because of the war circumstances, a lot of ships were stranded in between. The situation was not in their hands, right? They couldn't do anything, they couldn't move further. And because of, this was something that was completely unforeseen circumstance. Because of this, the goods got damaged. That is not gross negligence. That is where your force majeure clause will be applied. So you need to mention in detail with respect to this. Now, this is with respect to war, which is again unpredictable. Let's talk about, the sea transport itself. Let's talk about what if there is a storm. Now, if there is a storm, was all the precaution taken to ensure that the water doesn't enter the consignment? Now we know it's humanly impossible to be 100% accurate, but if I had kept it deeply inside and yet there was a very bad storm and water entered into the consignment, then it may not be that bad of a gross negligence, because the weather is again something that's not in my control. But if I am traveling, I have kept my consignment on the deck, and there is a pirate ship which comes at night and takes away my consignment very easily, then that is a gross negligence in this case. So understand what is the requirement of a client, what are the problems that may arise. You don't need to know the industry. All you need to know is use a little bit of common sense, because all these things I just spoke by applying basic knowledge. Talk to the people, and these days you have internet, so it's very easy to understand what are the challenges that your client is going to face depending on their industry. The reason why definition clause is so important is because your definitions always control the interpretation. So when I spoke about gross negligence, where does the gross negligence begins? It begins wherein you knew something like this will happen, yet you did not take any action. But if there is a loss which is caused due to some circumstance which is not at all in my control, then that is not gross negligence. So defining your term depending on requirement of your client and protection of your client is what will make you a smart lawyer. So a smart lawyer always spends significant time on definitions, because a lot of disputes often arise from interpretation. And again, a dumb lawyer makes the biggest mistake of copy pasting the definition clause. Seen a lot of founders do it. Then moving on to the sixth biggest mistake, that is not thinking about disputes before drafting. One thing that my seniors and elders always told me is always, even before you start drafting a contract, assume your contract is going to go in litigation. That is the most easiest way to cover. So, you technically think like a defendant who is going to attack your contract. Try to remove all the loopholes. That is going to be your step 2. Your step 1 will be taking notes from the clients, your client counseling. Step 2 will be drafting the first draft. Step 3 will be, just conduct a complete postmortem of your contract. Because many people, they generally assume that everyone will always behave nicely and, it's going to be a honeymoon phase forever. But trust me, contracts are never about honeymoon phase. It's about a messy marriage. Okay. So it's very unrealistic. It's very unpredictable. And that is why we are putting everything in writing. So a good lawyer will always think about what happens if this relationship collapses. Uh, you always need to draft, presuming there is going to be a conflict in future. So you have to always consider your exit clauses, your termination rights, your notice period, your payment defaults, your limitation of liability, what is going to be your indemnity, what are your governing law. If you have two parties, let's say two parties within India itself. So you have one party who's from Pondicherry, one party who's from Maharashtra. Which law are you going to apply? Is it going to be the, even though majority of the laws in India are same, there may be certain nuances with respect to certain laws which is different. You have your arbitration mechanism. Again, are you going to go for arbitration? Are you going to go for mediation? Your force majeure, again, depending on the circumstances. So if you may be aware, post-war, a lot of insurance terms have been changed by the insurance companies. Look up to it. Understand what is the latest in trend in the industry going. A good lawyer always keeps up with the current news that is going. So a contract is a document which is not only trusted, or it is not only tested during good times, it is also tested during your disputes. Again, one of the biggest professional mistakes that a lot of people do is no multiple iterations of review process. As I said, your first step will be taking the client input, your client counseling, understanding the requirements of the client, drafting the contract, then just do a postmortem, like your agreement has gone for litigation and you are the lawyer of the defendant trying to remove the fault. One of the biggest mistakes a lot of professionals make is assuming the first draft is good enough. Your professional drafting often requires iterations. A proper drafting or workflow often looks like, there is a first draft, which will understand the transaction sector. Your second draft, which will focus more on what is the risk allocation. Your third draft will focus on what is the commercial negotiation. Your fourth draft will be on checking the legal consistency. Your fifth draft will be on, all your typography, your just uh, uh, justifying the font, making it look presentable. You cannot have an agreement in which the font size is 16. You need to have an agreement wherein the font size is 12. Making all those small changes also matter a lot. When we do, large transactions, a document is sometimes even reviewed for 100 times. I have personally done it. And that is done in a span of 1 week. So trust me, it's very frustrating. But then when the amount involved is huge, it becomes a mandate. Many a times law students often, underestimate how collaborative drafting is, because your drafting often includes negotiation, redlining, your comments from the clients, comments from the other side, comments from the other side lawyers, your internal approvals. A lot of times when companies are involved, maybe the person who's representing the company may not have the authority to take decision. He has to go back to his team. They will take back decision. They will have their internal meetings, internal approval. So maybe a clause will be 100% perfect according to you, but then your client may not agree because a lot of people are involved. You have to do your risk assessment, that maybe if I give up this much of my rights in this contract, what is going to be the future? Okay. So these are a few things that you have to keep in mind. Never send a document without cross-checking the dates, the names, the defined terms, clause consistency. It cannot be you said something in clause B and you're contradicting the same in clause D. Cross references. If I'm talking about annexure A will be the sale deed, wherein the seller had purchased the flat from the builder, then I need to cross check whether my annexure is the same, the signatures, the governing law, because sometimes one typo can also be a huge disaster. Let's talk about the eighth biggest mistake, which is ignoring the practical enforcement. Now, A lot of times, many clauses sound brilliant while, you write theoretically, you write all fancy language, but they fail when you try to apply it. One example I would like to give you is this draft. Okay, just listen to it. The employee shall not work anywhere in India for 10 years. We spoke about Section 27 a few moments ago. Is it enforceable? Is it practical? You may feel that, okay, I'll put in this clause and I'll try to restrict, I'll ensure that my, employee doesn't get a job anywhere else. You feel very powerful, but it's a dumb clause. It is not enforceable, it is not practical, it's a fantasy clause. Okay. So your client will ask for the sun, moon, stars, everything under the universe. But you need to be that gate checker, gatekeeper, and check, is this something that's sensible? Is it something that's enforceable? Will the court uphold it? Is it, something that's commercially realistic? Is it possible that we can comply? Will there be any charges in compliance? All this is the duty of the lawyer. As I said, you have to be the gatekeeper in this particular case. Now, let's talk about the ninth mistake, not understanding the dynamics of negotiation. So, as I said, that sometimes negotiation is not about who is the loudest in the room. One tip I'll tell you, whenever we sit for drafting, okay, this is my personal observation, it may or may not be true, but for me, touchwood, 99%, 100% of the times it has been true. Whenever the other side creates a drama, okay, they'll argue on the most silliest point. And you will also end up arguing on the most silliest point. They'll do all sort of drama, and your client will be like, why are you not doing drama? She shouted on us so much. She screamed on us so much. She insulted me, this, that. Understand that is when they want to delay. Negotiation, to understand negotiation, you need to understand psychology. You need to understand human behavior, why they behave when they behave. So my personal experience says that whenever other side is creating drama, never encourage them. Be polite, be patient. Negotiations test your patience level. Never be rude. Always be polished. Always be dignified in the room. That is what will earn you respect in the long term. You may be the junior most in the room, but the way you carry yourself, the way you're calm, is what will make people notice you. A lot of people have this misunderstanding that, you need to be the loudest in the room to get attention. But sometimes it's your comfort level which will get you the most attention. So your drafting is also a negotiation psychology. Every clause, it reflects your bargaining power. For example, your strong indemnity clauses, they favor one side. Your strict termination rights, they favor another side. Your broad IP ownership, it always favors one side. Understand, no contracts are neutral. They are not. Every word has a certain risk. How you interpret them is a different ballgame. So let's come down to our last mistake. That is drafting of your contract without ethics or professional responsibility. There is a saying, it's a very bad saying and I don't agree with it, that they used to say that lawyers who work in big law firm are nothing but glorified clerks. That is basically the people who do only non-litigation. So litigation people hate people like me. We only do contracts. So you need to remember that lawyers are not merely writers. They are officers of the legal system. So never mislead the client. Tell them honestly, this can be done, this cannot be done. Never hide the risky client, the risky clauses. Now, you may want to close an agreement because you're going on a vacation, but a clause can have a reverse effect. Maybe not today, maybe in 5 or 10 years. Explain it. Always keep a copy of your confidential documents. Always keep it on the cloud or keep it in your hard drive. Draft, never enter into any illegal agreements. For example, surrogacy. A lot of people don't understand the nuances of surrogacy, enter into some ridiculous surrogacy agreement. I don't even want to talk about it. It is that insensitive. I don't understand how can a lawyer be so insensitive. Never misrepresent enforceability. Tell your client, this is how this contract is going to be enforceable. Don't, your contract is not a fantasy fiction. It is a practically enforceable document. Now, let's talk about why. Because when you talk about contract drafting, it also depends on your professional reputation. When you want a job for contract drafting, it also matters what type of person you are. Your nature. Are you a person who is always partial, always one-sided, or are you a person who is diplomatic and knows how to maintain the balance? So professional reputation and drafting, it takes years to build, but it just takes minutes to destroy. Now let's talk about how do I begin with drafting? Okay, so before drafting any agreement, you need to ask yourself these basic 10 questions. That is, what is the transaction? What law does it govern? What are the risks that exist? What exactly does the client want? What could go wrong? Which clauses are there which is legally mandatory? Which clauses are something that's commercially negotiable? Is my language clear? Is the agreement enforceable? Have I reviewed this draft multiple times? These are 10 basic questions, which is going to be your mantra. And you need to ask this question to yourself before you even send the document. If you are someone who wants to be a good lawyer, in this non-litigation field, a good drafting lawyer, you always need to remember that a great drafting is not about using all fancy, difficult English. It is never about, which is the most fanciest template that you can use. It is not about how hi-fi or how sophisticated you are. A great drafting is always about understanding people, that is your clients, the opposite person, understanding the nature of business, understanding the risk, why this agreement is required, what is the risk that they are trying to avoid, understanding the law, and then communicating all of this properly in your agreement. So your contract is not just a roadmap, it's a dispute prevention tool, as I would like to say. It is something that will help you to keep a record of your negotiation. It is something that will, tell that, okay, this is the risk that is allotted to you. This is the risk that is allotted to you. Sometimes the difference between financial safety and disaster. So it is not that, the best lawyers are not the ones who draft the longest agreements. They are usually the ones who draft agreements that actually work, that are actually enforceable and applicable in real life. And that skill is what will make you invaluable. Thank you so much, and do follow me for more such interesting contract tips and other. Thank you.